Civil Procedure Code Practice Questions Session 9. In this session, we will discuss the questions that may be asked in Judicial Services examination. We help the students in preparation of Judicial Services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. Question number 201. Every pleading must state option A, material facts as the basis of claim or defense. Option B, law or legal pleas as the basis of claim or defense. Option C, evidence of alleged facts. Option D, all of the above. Every pleading must state material facts as the basis of claim or defense. Answer is option A. Order 6 of Civil Procedure Code, Order 6 of Civil Procedure Code deals with pleading. There are 4 basic rules of pleading. Pleading should state facts, not law. Pleading should state facts, not law. Second rule is the facts stated should be material facts. Rule number 3, pleadings should not state the evidence. Pleading should not state the evidence. Rule number 4, the facts should be stated in a concise form. These are the following general principles of pleading. Fundamental principles of pleading. Pleading should state facts, not law. The facts stated should be material facts. Pleading should not state the evidence. The facts should be stated in a concise form. Question number 202. Who said pleadings are statements which are written and prepared in every case by a plaintiff? These contain all those facts on the basis of which case is to be decided and the defendant is to file his written statement. Option A, Lord Denning. Option B, P.C. Moga. Option C, Justice Bhagwati. Option D, Lord Halsbury. Answer is option B. B is the answer. P.C. Moga said, pleadings are statements which are written and prepared in every case by a plaintiff. These contain all those facts on the basis of which case is to be decided and the defendant is to file his written statement. Question number 203. Which order of the CPC lays down general rules governing pleadings in a court? Option A, Order 6. Option B, Order 7. Option C, Order 8. Option D, Order 9. Answer is option A. Order 6 of Civil Procedure Code lays down general rules governing pleading. Order 6, pleading. Generally. Order 7 deals with plaint. Order 8 deals with written statement set off and counterclaim. Order 9 deals with appearance of parties and consequence of non-appearance. So answer is option A. A is the answer. Question number 204. A pleading need not contain. Option A, presumption of law. Option B, performance of condition precedent. Option C, circumstances from which the intention may be inferred. Option D, all of the above. A pleading need not contain presumption of law. A pleading need not contain performance of condition precedent. A pleading need not contain circumstances from which the intention may be inferred. So answer is option D. D is the answer. Question number 205. No pleading can, except by way of amendment, raise any new ground of claim or allege any fact inconsistent with the previous pleadings of a party. This is laid down in option A, Order 6, Rule 5. Option B, Order 6, Rule 6. Option C, Order 6, Rule 7. Option D, Order 6, Rule 8. Order 6, Rule 5. Further and better statement or particulars. Order 6, Rule 5 has been repealed by the Code of Civil Procedure Amendment Act 1999. Order 6, Rule 6 that deals with condition precedent. Any condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in his pleading by the plaintiff or defendant, as the case may be, and subject thereto an avertment of the performance or occurrence of all conditions precedent necessary for the case of the plaintiff or defendant shall be implied in his pleading. Order 6, Rule 7 deals with departure. No pleading shall, except by way of amendment, raise any new ground of claim or contain any allegation of fact inconsistent with the previous pleadings of the party pleading the same. So answer is option C. Order 6, Rule 8 deals with denial of contract. Where a contract is alleged in any pleading, a bare denial of the same by the opposite party shall be construed only as a denial in fact of the express contract alleged or of the matters of fact from which the same may be implied, and not as a denial of the legality or sufficiency in law of such contract. Answer is Option C. According to Order 6, Rule 7, no pleading can, except by way of amendment, raise any new ground of claim or allege any fact inconsistent with the previous pleadings of a party. Question number 206. Where an agreement is alleged, the pleading should state: Option A, date of the agreement. Option B, written or oral agreement. Option C, if implied agreement, the facts or circumstances from which it is to be so implied. Option C, all of the above. Where an agreement is alleged, pleading should state: date of the agreement, written or oral agreement, if implied agreement, the facts or circumstances from which it is to be so implied. So answer is option D. D is the answer. Question number 207. Which of the following is not essential in respect of a pleading? Option A, it should be signed by the party. Option B, it should contain a complete address of the party. Option C, it should be verified by the party's pleader. Option C, it should be verified by the party's pleader, is not an essential in respect of a pleading. So answer is option C. C is the answer. Question number 208. Pleadings must be signed. Option A, by the party only. Option B, by the pleader only. Option C, by the party or his agent only. Option D, by the party or his agent and his pleader, if any. Pleading must be signed by the party or his agent and his pleader, if any. So answer is option D. D is the answer. Question number 209. Mark the incorrect statement. Option A, specimen forms of pleading are given in Appendix A to the CPC. Where such forms are not applicable, a form which is similar is to be used. This is correct statement. Option B. If there are two or more plaintiffs, only one of them need verify the plaint. This is also correct statement. Option C. The person verifying the pleadings is also to furnish an affidavit in support of his pleadings. This is also an correct statement. Option D. Omission to verify or a defective verification cannot be remedied at the later stage. This is incorrect statement. Omission to verify or a defective verification cannot be remedied at a later stage is incorrect statement. So answer is option D. D is the answer. Question number 210. Order 6, Rule 16 empowers the court at any stage of the pleadings to strike out any matter contained in it. Option A, if it is unnecessary, scandalous, frivolous, and vexatious. Option B, if it tends to prejudice, embarrass, or delay the fair trial of the suit. Option C, if it is an abuse of the process of the court. Order 6 Rule 16 empowers the court at any stage of the pleadings to strike out any matter contained in it if it is unnecessary, scandalous, frivolous, or vexatious. If it tends to prejudice, embarrass, or delay the fair trial of the suit. If it is an abuse of the process of the court. So answer is option D. D is the answer. Question number 211. A party may approach the court for an amendment of his opponent's pleading, also known as compulsory amendment, if it is provided for under option A, Order 6, Rule 14, option B, Order 6, Rule 16, option C, Order 6, Rule 17, option D, Order 6, Rule 18. Answer is option B. Option B is the answer. Order 6 Rule 14 deals with pleading to be signed. Order 6 Rules 16 deals with striking out pleadings. Order 6 Rule 17 deals with amendment of pleadings. Order 6 Rule 18 deals with failure to amend after order. Order 6 Rule 14 pleadings to be signed. Every pleading shall be signed by the party and his pleader, if any, provided that where a party pleading is by reason of absence or for the other good cause unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or to sue or defend on his behalf. Order 6, Rule 16 deals with striking out pleadings. The court may, at any stage of the proceedings, order to be struck out or amended any matter in any pleading, which may be unnecessary, scandalous, frivolous, or vexatious, which may tend to prejudice, embarrass, or delay the fair trial of the suit, which is otherwise an abuse of the process of the कोर्ट. ये ऑर्डर 6 रूल 16 ही है जिसमें कोर्ट किसी भी स्टेज पर, प्रोसीडिंग की किसी भी स्टेज पर प्लीडिंग को स्ट्रक आउट कर सकती है या अमेंड कर सकती है अगर कोर्ट को लगता है प्लीडिंग अननेसेसरी है, स्कैंडुलस है, फ्रिवोलियस है. जो प्लीडिंग है फेयर ट्रायल को डिले कर रही है या कोर्ट को लगता है कि कोर्ट के प्रोसेस का एब्यूज हो रहा है, कोर्ट के प्रोसेस का गलत इस्तेमाल हो रहा है. सो आंसर इज ऑर्डर 6 रूल 16. क्वेश्चन नंबर 212. Amending one's own pleading voluntarily amendment is provided for under option A, order 6 rule 14, option B, order 6 rule 15, option C, order 6 rule 17, option D, order 6 rule 18. Order 6 rule 15 deals with verification of pleadings. I am again repeating order 6 rule 17. Order 6 rule 17 deals with amendment of pleadings. The court may, at any stage of the proceedings, allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that, in spite of the due diligence, the party could not have raised the matter before the commencement of trial. Answer is Order 6, Rule 17. This is amending one's own pleading voluntary amendment. Order 6, Rule 17 provides the voluntary amendment of pleading. Answer is option C. Question number 213. Under Order 6, Rule 17. Option A. The court may at any stage of the proceedings allow either party to alter or amend his pleadings. Option B. The court may at any stage of the proceeding allow a plaintiff to alter or amend his pleadings. Option C. The court may at any stage of the proceedings allow the defendant alter or amend his pleadings. Option D. The court may at the appellate stage of the proceedings allow either party to alter or amend his pleadings. Under Order 6, Rule 17, the court may at any stage of the proceedings allow either party to alter or amend his pleadings. Answer is option A. Question number 214. The object behind the amendment of pleadings is option A. To enable the real question in issue between the parties to be raised on the pleadings for the purpose of adjudication between the parties. Option B. To decide the right of the parties and not to punish them for the mistake they make in the conduct of their case. Option C. To prevent multiplicity of suits and shorten litigation. Option D. All of the above. The object behind the amendment of pleading is to enable the real question in issue between the parties to be raised on the pleadings for the purpose of adjudication between the parties. The object behind the amendment of pleading is to decide the right of the parties and not to punish them for the mistake they make in conduct of their case. The object behind the amendment of pleading is to prevent the multiplicity of suits and shorten litigation. So answer is option D. D is the answer. Question number 215. In which of the following cases amendment of pleading could be allowed? Amendment of pleading could be allowed for granting relief on the basis of different approaches to the same facts. Amendment of pleading could be allowed when amendment taking note of subsequent events. So, answer is option D. D is the answer. D is the answer. Question number 216. A's furniture was wrongfully removed by B and C. A sued B for damages and for judgment against A. A then sued C for damages for the same wrong. After A's evidence was over, C applied for amendment of written statement by pleading judgment against B as a bar to suit against him. B and C being wrongdoers, the judgment against B precluded A from suing C for the same wrong. Option A. Amendment should be allowed. Option B. Amendment should not be allowed. Option C. The amendment should not be allowed since it was not necessary to decide the real question in controversy between the parties. Option D. The amendment should be allowed as C can avail himself the benefit of technical rule of law. Answer is option C. The amendment should not be allowed since it was not necessary to decide the real question in controversy between the parties. Answer is option C. Question number 217. Which of the following cases amendment of pleading could not be allowed? Option A. Where the parties in the plaint are wrongly described. In this type of case, amendment is allowed. Option B. A bona fide omission in making the necessary avertments in the plaint. Amendment is allowed. Option C. A suit is brought under a wrong act. Amendment is allowed. Option D. Where a suit is brought against a person who is found to have died before its institution. The plaintiff amended by bringing his legal representative on the record. The suit was filed in ignorance of his death. In situation D, amendment of pleadings could not be allowed. So answer is option D. D is the answer. Question number 218. Mark the correct statement. Option A. Leave to amend may be granted at any stage of the proceedings. Correct? Option B. Amendment applications are not governed by any law of limitation. Correct? Option C. Amendment may be granted before, at or after the trial, or in the first appeal, or in second appeal, or in revision, or in the Supreme Court, or even in execution proceedings, provided the decree is legal, lawful, and enforceable, not otherwise. This is also correct statement. Answer is option D. D is the answer. All statements are correct. Question number 219. In which of the following cases the court would allow an amendment? Option A. A karta of a Hindu joint family brings a suit against a company in the business name. The defendant company raises the objection that since the firm is an unregistered one, it is incompetent to sue. Thereupon, A seeks to amend the plaint to the effect that he was suing in the name of the family as the karta or manager. In this case, amendment is allowed. Court would allow an amendment. Option B. A filed a suit for partition of his ancestral house. He prays in the suit only for a decree of partition. The case after evidence and arguments was fixed for orders. Then A files an application to amend the prayer clause in the suit to the extent that he be granted a decree of partition and also of possession of the suit premises. In this case, court would not allow an amendment. So answer is option A. A is the answer. Question number 220. If a party who has obtained an order for leave to amend pleading does not amend the same within how many days? Within how many days he shall not be permitted to do without leave of the court? Option A 15 days, option B 14 days, option C 20 days, option D 30 days. Answer is option B. B is the answer. Question number 221. Which of the following statements is correct? Option A. No application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that, in spite of due diligence, the party could not have raised the matter before the commencement of trial. This statement is correct statement, option B. If a party who has obtained an order for leave to amend does not amend accordingly within the time fixed by the order, or if no such time fixed within 14 days from the date of order, he shall not be permitted afterwards unless the court extends the time. This is also correct statement, option C. No appeal lies from an order granting or refusing an amendment under Rule 17. This is also correct statement. So answer is option D. Option D is the answer. Question number 222. An amendment in pleading will be effective from the date of the option A order, option B application, option C pleading, option D none of the above. An amendment in pleading will be effective from the date of the pleading. Answer is option C. Question number 223. The provision for the institution of suits is given in which of the following sections of the code? Option A, section 26, option B, section 30, option C, section 28, option D, section 25. Section 26 deals with institution of suits. Section 30 deals with power to order, discovery and the like. Discovery and the like. Section 28 deals with service of summon where defendant reside in another state. Section 25 deals with power of Supreme Court to transfer suit. Section 26 of Civil Procedure Code deals with the institution of suits. So answer is option A. A is the answer. Question number 224. Section 26 lays down that every suit is to be instituted by the presentation of plaint. In which of the following courts a plaint has to be presented? Option A, court of the lowest grade. Option B, court of the lowest grade even if incompetent to try the suit. Option C, court of the highest grade. Option D, district court. Section 26 lays down that every suit is to be instituted by the presentation of plaint. A plaint has to be presented in the court of the lowest grade. Answer is option A. Question number 225. A plaint has to be presented in option A, single copy. Option B, duplicate. Option C, triplicate. Option D, no fixed rule. A plaint has to be presented in duplicate. Answer is option B. Option B is the answer. We help the students in preparation of judicial services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. Please feel free to contact us at legalbuddy@gmail.com. Thank you.